Welcome everybody. Welcome to this E2 Wealthier coffee break. It's a continuing theme and supported by the brilliant Rebecca. Is that building work going on in the background, Rebecca? No, you're on mute. The brilliant Rebecca, who has come and helped us on other subjects. Today's subject, I think, is probably one of the most important of the discussion on managing and supporting your own wealth. And because it is all about protecting your wealth in terms of wills, and in terms of looking after your living wealth in terms of powers of attorney. Let's make this interactive. It's really important. I'm sure questions along the way. Rebecca hasn't got any slides, but is open to being interrupted. Is that right, Rebecca?
Yes, definitely.
Brilliant. Rebecca, I'm going to just pass over to you and then I'm going to wait for 10 seconds and interrupt you. So go. And if you want to interrupt, talk or anything, just put your hand up. And we'll get you on the call. This is an important and quite detailed subject. Rebecca, over to you.
Absolutely, Mark. Thank you, Mark, Katie, and the rest of the E2 Wealthier team for welcoming me back. It's good to see you. It's good to see lots of familiar names, but it's also good to see lots of names I haven't seen before. So just to show that the expanse of the E2W network. And I just want to start this little chat, and I do want it to be an informal chat. So as Mark says, please do interrupt or write questions in the chat if there's anything you want me to discuss as we go along, and then we'll obviously open it up for more discussion at the end. I just want to start by saying, as I do at the beginning of all of my talks, this is for information only, and this is not advice, just to cover me on that side of things. Now, today's topic is the financial side of wills and lasting powers of attorney. So the essentials to protect your family. Mark and I had, I think it was in about December time now, and agreed that this was a hugely important topic, both, for yourselves, for your parents, for your grandparents. And given that an increasing number of people are living in blended families, and sometimes the laws of intestacy, etc., can get blurred, and things such as stepchildren do not get looked after. So it's imperative that you do address this personally. And also, very importantly, it's important that you've got control over your assets after death, to prevent any family squabbles as well. No one wants to leave a fight behind them. Now, I am looking at this from a financial planner's point of view. I'm not a lawyer or a will writer, and I would recommend that you engage one of those when you do write your will and your powers of attorney. It's really topical this week, given it's Mental Health Week. Now, I am a big advocate for financial well-being and its importance in your overall well-being. Now, we all know stress and anxiety can be caused and tied up with financial stress, and how it can impact much personal and professional lives. Now, for me, financial well-being covers a whole host of things. It covers a healthy relationship with money. It covers, having control over your day-to-day finances, having a cushion with which to soften any financial emergencies, being able to manage your liabilities, being on track or at least have a plan for your savings and retirement goals, and having the legal documentation in place, knowing that your responsibilities and assets would be looked after in the event of you dying or becoming seriously ill. Writing a will gives you that power to ensure that your estate responsibilities would be distributed and taken care of the way that you wish after death. Yet why do only 40% of adults in the UK have a valid will? Now, my question to you is, and I know there's a lot of cameras which are off, I'd love a yes or no in the chat. Who here has got a valid will? Answer, either put your hand up or yes or no. Mark has, and he's proud. I see some no's. I see a lot of people who are not admitting to it. So that makes me think, okay, not yet, no, yes, yes. Sorting mine out this week, like that. Not valid, okay. And if you haven't got one, yes, but ripped it up, okay. No. If you haven't got one, what is it holding you back?
It's complicated.
Complicated?
I just feel like I've got time, but last year's kind of made me think there's never the right time.
We'll get mine done. Couldn't agree. Who would keep the kids? Yeah, that is really common. It's highly emotional. Any other reasons why we haven't got around to doing these wills?
I know it sounds probably quite naive, but I guess it's my age. I just hadn't thought about it just yet.
Yeah, not old enough. Don't want to address it. Too scared. Can't face having a conversation with my husband.
Worried you're going to put something in place that might not be relevant in that far in the future.
Another good thing, remember, your will does not have to be forever. You can change your will, and you can add small amendments via a codicil, or you can update your will. No, there is nothing. Your will now, the chances are the will that you put in place now won't be the will that you have in place when you're 70.
Rebecca,
it's great
can I just
adding in and removing gifts to errant nieces and nephews? Love that.
Can I just butt in there, because I think it took us 20 years almost 20 years after we got married, Tina and I, to put our wills in place, and it was always the elephant in the room. It was always basically. So I have two children of my own. Tina has a child of her own, and there was always this big question mark about, how are we going to, if we die, when we die, how are we going to split the assets? What happens if I die and she gets married? How do I protect what happens to my kids, and the other way round, and all these things? And we never actually got around to talking about it. Actually, when we did then sit down and we got somebody to come in, a will writer, and write our wills, it was like a weight taken off of our shoulders, a real weight taken off of our shoulders. Yeah, we went through a couple of months of this and that. Well, that's not fair, and what happens if, and all this kind of stuff. And I see Laura and a few people nodding. But once we got it sorted, it was like a big, thank for that. Because we've done it now, it's behind us. We've had those discussions, we've had those conversations, and we've got to a point, with the help of the will writer and the financial advisor, that actually just sorts it all out. We're not multimillionaires. We've got a bit to leave, but it just sorted it all out. And I'd recommend all of those people that don't want the conversation, have the conversation, because it's a big relief. Sorry, I'm going to.
Someone's just asked me, but I'm just going to, instead of me trying to type, no, I totally agree. And I would say that often it's the thought that is actually worse than the action. Actually, once you've done it, the relief of knowing that you've got it all set in place and you've got control over it is just so important. To the person who's asked me, how many times can you change the will and what are the cost implications? You're taking a lawyer's time, so there are going to be cost implications, but surely the cost implications, it's more important that all your wishes are in place as they're, as you would want, rather than paying, a little bit extra for a lawyer. And small changes can be added and just amended, but if it's a massive change, the will would need updating. And again, the price of wills does vary depending on who you go to. What happens if we have no will? Someone said, I'm actually just about to come to that. In fact, you all have a will. If you die without your own will, then the state decides where your assets go. Okay, and that is under the rules of intestacy. So what are the intestacy laws in England and Wales? If you are married, then 100% of it would go to your spouse. If you are if you are married with no children. If you're married with children, then the first 250,000 would go to your spouse, and then the balance would be split 50-50, 50 to your spouse or civil partner, and the remaining 50 would be divided between your children. And if your children predecease you, it would go to their children. If you are not married and you don't have any children, then your estate would go in this order. Sorry, if you are not married, then your estate would be distributed in this order to any of your children and to your parents, siblings, grandparents. And if you have no living relatives, the Crown will inherit your hard-earned assets. There is no provision for non-legal relationships or stepchildren. And
sorry, Rebecca, what did you say that I missed the middle bit about grandparents, the one after the kids and spouse?
Yeah, but it's basically if you're not legally married, and
yes,
then it would be the order that it would be distributed in would be to your children, to any children you've got, then to your parents, then to any siblings, and if you don't have any of those but you still happen to have some grandparents, then it would go to your grandparents.
Sorry, thank you.
Okay, but if there's no living relatives, it will go to the state.
And what does it mean if you have a partner but you are not married?
Then there is no provision for non-legal relationships. So it's only if you are married, or civil partner, that counts. But if you are just living with somebody, then they are not covered by these rules.
Yeah.
So they do not get anything.
Does it cover my nieces eventually? So daughter of my sibling, etc.
It would eventually. However, the best thing to do is if your wishes for the distribution of your estate are not in accordance with the order of inheritance set out under the laws of intestate, it is important to write your own will.
Yeah.
Okay. Just to save them having to find, it just saves an awful lot of stress. People having to find exactly, you may want it to go to your nieces before your parents, for example, but it wouldn't in that order.
But it will eventually go to my nieces.
It's much easier just to direct.
Write
your will and make sure that it goes to exactly who you want when you want.
Perfect. Thank you.
And it is, Katie, never too early to write your will.
Good point. Thank you.
Okay, you might think you haven't got anything enough, a big, huge estate to leave, but I bet you do. I bet you've got, even if it's personal possessions, it doesn't have to be monetary value. It can be sentimental value as well. And if you have children under the age of 18, it is part of your responsibility to your children to make a will. Wills are not all about money. It allows you to appoint guardians for your children. And if plans aren't outlined in a will, and with both parents, if both parents are deceased, if there aren't any plans in your will, your local authority or the court could be left to decide who looks after your children. Is there anything more important or frightening than that? I don't think so. You would also need to appoint an executor whose job it would be to look after the will on the point of your death, to make sure that the assets were distributed in line with your wishes. And if you've got kids under the age of 18, potentially a trustee to look after the money for them, to work out when they get the money, if it's not specified in the will, how much money goes to the guardians to help with the looking after of it, and perhaps you've got a much loved but untrustworthy child. Again, that does need to be, it can be looked after. And of course, all your wishes need to be noted, which includes personal wishes and business wishes. Now, when I talk to my clients about their wills, the scenarios that I chat to them about, which they then go and talk to their lawyers about, I just get them to try and imagine lots of different situations. So who will look after any children? Who will look after any pets? How much money will be distributed to the children? When will it be distributed? The age, the guardians, etc. Is there enough money to bring the children up? If both parents died and there could well be a property to sell, is there enough capital in that property to look after those children? If one parent dies, actually, what's the financial impact on the family? Now, are there any life insurance policies, either personal or through work? And is there a trust arranged for those? So the policy is placed straight into the trust, which keeps the money out of your estate and also available straight away. You don't need probate to be granted. Really important. And again, financial provisions for pets. A lot of you don't have children, but you may well have, much loved pets that you would want to look after. There's a few questions on here, and I'm going to, actually, they're all being directed to me. What happens if I have no will directed that? Would you advise what makes a will valid or invalid? I will come to that. If a person is separated or divorced, who gets the asset? Coming to that. How do you appoint trustees? Trustees, you can use a lawyer, you can pay to have professional trustees. And a lot of the time the trust is only created on death, or you could use a trusted sibling. Ideally, it's somebody who is going to be around if you are no longer. So you wouldn't use your parents, because hopefully, our generation will outlive our parents. So a trusted friend or sibling, somebody that you can trust, and somebody who has the same morals as you have. I think that is really important. Another thing to consider is mirror wills. Now, a lot of the time, mirror wills are the cheapest form of will. So it would be a couple, I leave my half to my husband leaves his half to me. Easy. However, what would happen if I was to die and my husband then remarries? What would happen to my share of the estate? Perhaps an interest in possession trust could be considered, which would in effect give my husband Harry the right to use all of my estate during his lifetime. However, even if he was married to somebody else. However, on death, my estate would pass, it would be ring-fenced from his future spouse, and it would pass to our children rather than potentially being passed to his new spouse and potentially to her children, cutting our children out of it completely. For me, that is really important. And you never know, you can't control relationships after death, and neither would you probably want to, but you can ring fence, you can put provisions in place to ring fence those assets. A few other things to think about are marriage nullifies a will. So if you get married, you do need to do a new will, but divorce doesn't. Oh, well, only once the decree absolute comes through. So if you've got an ex-spouse who is not legally an ex, then they would still be entitled to inherit your estate, which is quite frightening. Non-legal relationships aren't protected, and there is no such thing as common law husbands and wives. So again, you've got to put this facility in place. Another scenario to think about is if you're a business owner, what would happen to the business? Now, for example, would my husband inherit? Okay, this is my own business, but if there were other directors, would my husband inherit my part of the business and have control over my part of the business? What would the other directors say? Would they want him, he doesn't know anything about financial planning, would they want him meddling in the business? But could they afford to buy him out? Or, could a shareholder protection policy be considered just to prevent this potentially tricky situation? If you've got assets overseas, that can be complicated, and often it's worth having a separate will in each relevant country. But that is a complication and needs a lot of attention. Now, when setting up a will, you can get cheap wills on the internet, but I would say it is always important to engage a professional. It is important to take legal advice because there will be a lot of things that you haven't thought of, and just to make sure that all eventualities are covered. The will doesn't have to be perfect. From now until you're 100, you can change it, and don't let perfection get in the way of getting something down on paper. And once done, you'll probably find that it is really not as bad as you thought, and the sense of relief and that the decisions have been made all within your control. And once you've got it as well, keep it in a safe place, because if it can't be found, it is as if it doesn't exist. So a lot of people pay for professional will storage, or if you've got a safe in your house or something, there's lots of ways, but it's really important that it is signed by 2 witnesses who are not beneficiaries, and it is kept in a safe place. Is it always personal will, or do couples get joint wills? Couples can have joint wills. That's the mirror wills, and that is when you might want to put some of those an interest in possession trust in place. There are cost implications. Sorry. Okay. Can't read that message properly. Anyway. So that is the process of making a will. Before we move on to powers of attorney, are there any more questions about that?
Rebecca, I know you're not able to talk about inheritance tax. So I'm just going to plant in there what my parents did, because I think it's important. So their joint estate would have come just slightly above inheritance tax limits, which aren't large in terms of, if you own a property in London, you'd probably be subject to inheritance tax. So they wrote wills where, when my dad died, all of his half of the estate went into a trust fund, where my mum had, I think you called it, legal right to use that trust fund, but on her death, it then comes directly to us. His half of the estate was lower than corporation inheritance tax, so we don't get any tax on it. My mum didn't own it, so her estate wasn't made twice as big as it should have been. When she dies, hopefully her estate will be under inheritance tax as well, and we get all of the estate from her will. It's worth looking into that, and when you're setting your will, go to an expert, or you think about your parents' wills or your wills, that you're doing something like that, so you can avoid inheritance tax if possible.
Yeah, no, 100%. And I think it's worth noting that, particularly in the south of England, and the inheritance thresholds, if you own a property, they're not huge. It's 325,000 per person, plus another 175,000 per person. Sorry, the first 325 is inheritance tax free. And then there is 175,000 per person, which is your residence nil rate band. So as long as that money comes from your primary residence and it is passed to a direct descendant, so that is either a child, a grandchild, or a stepchild. And another caveat as well, as long as your estate is worth less than £2 million. If your estate is worth more than £2 million, then you lose out on that resident nil rate tax band. So, and again, it's really, and actually I may as well say this, how are we doing for time? Lasting powers of attorney doesn't take very long. I was actually writing a little list of how you can reduce your inheritance tax liability. And the first one is writing your will, because all your assets would go to your spouse. You don't pay inheritance tax if your spouse inherits your assets. And if you didn't, as Mark's parents did, set up a trust, his mum would still inherit his father's 325 nil rate tax band and also the 175 residence nil rate tax band. So in effect, there is £1 million which you can have in your estate before you pay any tax. The rate of inheritance tax is 40% though on anything additional. It's also just some other things, is just to make sure that any of your policies, whether they be personal or whether they be personal life insurance or work life insurance, they are paid into a trust. And a lot of insurance companies have got a trust that you can pay it into, or I know the ones that I do, we just set up a shell trust. It costs nothing because it's not used until, it's only used in the event that you appoint trustees. Most people do, like their best friend or brother and sister, etc., and then just leave it as that. And children who are over the age of 18, they can become trustees as well as beneficiaries. A couple of other ways to reduce inheritance tax liability is the order in which you spend your assets. Pensions are not liable for inheritance tax. If you die before the age of 75, your inheritance tax, as long as it's not over the as long as it's over the lifetime allowance of approximately 1.2 million, your beneficiaries inherit that pot tax-free. Over the age of 75, then they inherit your beneficiaries pay income tax at their rate, their nominal rate on the money when they take the money. So there may be a basic rate taxpayer and they pay 20% on it rather than inheritance tax of 40%. Okay, and also you can make gifts. We covered that in the last session. There are some small gifts that you can make every year, and you can look at putting some investments into trust. And I know somebody in the last meeting asked what happens if you put a property into trust. If you dispose of a property into trust, you do actually still have to pay the capital gains tax on it, because it is a disposal of an asset from your estate, and then it will go into trust. And there's different charging with trust. We could do a session on that, but it's really complicated to cover now. But it's just to give you a little taste of some of the things that you can look at to make sure that HMRC does not become your parents, your grandparents' favourite child. Are there any other questions before we go on to the lasting powers of attorney?
Sorry, Rebecca, will you be able to send us some direction how to get more information on trust or minimizing tax regarding, if you can just give us some.
Mary, why don't we could just do a 30-minute chat about it, and I could find out specifically a bit more information about what you're looking to do, and then send you the relevant information, because it's a really broad subject.
Thanks. Yeah.
Feel free to reach out to me. Just send me a message on LinkedIn, and we can just get a quick chat in the diary, and I can send you the relevant information.
Thank you so much. Yeah.
No, my pleasure. So, shall we move on to lasting powers of attorney? I take that as a yes. Can't wait. So wills are relevant on death. Lasting powers of attorney, they protect you in the event that something happens to you in the future, from you being able to manage your finances or make decisions about your health or your welfare. They cover you in the event of illness or accident or old age that leads to mental or physical incapacity. And it's good to know that there'll be somebody there to take care of your needs. Many believe that this would only happens in old age, but let's face it, nobody is immune from unfortunate circumstances. An LPA, a lasting power of attorney, which is shortened to LPA, is the donor, so it's the individual giving one or more people, attorneys, permission to make decisions on their behalf if you lack the mental or physical capacity to do it yourself, or you choose not to make those decisions. And essentially, LPAs should be prepared when you are fit and well, and then just filed away safely should you ever need them. They cannot be written once you have lost capacity. They're almost like an insurance policy. You put them in the drawer, you set them up just in case, and you register with them with the Court of Public Guardians, and then you forget about them until, as and when they are needed. One story that I'm sure you've all heard of this year was the story of Good Morning Britain presenter Kate Garraway. Now, we've all heard about her husband, Derek Draper, who is in his 50s fighting COVID. I mean, it's been over a year now. He is now at home, but he has been in a coma for a lot of the year. And Kate has spoken about the financial struggles that they as a family have faced because Derek did not have any LPAs in place. So many of the assets were in Derek's name. The insurance, the household bills, joint accounts were frozen. And, no one could deal with Derek's affairs when he was not able to, not even his wife. Had Derek had an LPA in place, Kate would have been able to sort out the finances. I think they also wanted to remortgage their house and they weren't able to. Had there been an LPA in place, Kate would have been able to look after those finances and would not have had the worry that she has had at what must have been a hideous year for them. Now, in England and Wales, there are two types of lasting powers of attorney. The short name for them is there's the health and there's the wealth. So starting with health and welfare, this includes decisions related to one's daily routine, medical care, whether to put somebody in a residential home. And this is only used once somebody is unable to make their decisions. The property and finance one, so the wealth LPA, this can be used for decisions such as, for bank accounts, for paying bills, for pension payments. A lot of people now are in flexi drawdown pensions. They haven't bought a guaranteed annuity, and actually they need to have regular updates about how much money they're drawing from their funds, what their funds are doing. And without that authority, you could really be your income could really be affected. Also, selling a home, if somebody's going into residential care, you need to have the authority to sell their home to potentially pay for that residential care. And the property and finance LPA, that can be used as soon as it's registered. Depends on the individual. Some individuals, they might be able to make the decision, but they may choose not to, and they may be happy to leave those decisions to their children or another attorney that they have appointed. And it's also important business-wise, you can appoint an attorney for your personal affairs, and you can appoint attorney for your business affairs. Again, you might not want your husband or best friend making your business decisions for you. It might not be the best. So what happens if you don't have one of these? Well, your accounts could well be frozen and no financial decisions and access to assets nobody will be able to have access to your assets and make decisions on your behalf without going to the Court of Public Guardian, and they need to appoint somebody who can make those decisions and take that control, and that can be a long and expensive procedure. And similarly, if decisions need to be made about medical treatment without an LPA in place, a family loses their authority to make those decisions. LPAs are only valid when the donor is alive. Upon death, the will becomes valid. And as with wills, I highly recommend that you go and seek legal advice to get these sorted out, and do not take anything so important. Do not leave it to chance. Make sure it's done properly. Again, a lot of people think they can DIY it, but actually, how many times have you done it? Probably once. You may well make a decision and the powers of attorney be invalid and potentially expose yourself in the future.
Rebecca, it might be a silly question. I'm getting my head around it. So the 2 LPAs you've mentioned, that's on top of the will, or they're part of the will?
No, they're separate. So you do the will. You can a lot of people go to their lawyer, they go to the will writer, and they do it all together. However, they are separate. You've got your will, which is in effect looking after your wishes upon death. Okay. And the lasting powers of attorney, so the 2 of them, health and wealth, are looking after your affairs in the event that you are unable to whilst you are living. So either illness, old age, accident, COVID, any of that.
Okay, thank you.
Yeah, Rebecca, with the LPAs, you have to have 2. You can have both health and wealth, and can they be together, or do you have to actually execute them separately?
They are separate. I think you can just do one of them, but I think most people think if they're going through the ordeal of setting it up, you may as well just do both.
Yeah, but they have to be 2 separate documents.
They are separate. Yes, because also you might want somebody in charge of your finances, but you don't want them in charge. You might have your daughter might be brilliant with finances. Right. Your son might be really caring. So you might leave the health decisions to your son and the financial decisions to your daughter.
Okay. Thank you.
Are these what Britney Spears did then? Sorry, a bit.
I don't know that. Sorry, what did she do?
Britney Spears, her dad took control of her estate. So is that what they would have put in place, these 2 documents?
No, but what happened to Britney Spears?
She had the breakdown in her early stage, and there's a battle going on at the minute, right? Where I think
I don't know.
Okay.
I'm normally really up on my trash stories, but I haven't read that.
Because I've not heard of these LPAs before, so that's new to me. So that's really helpful. Thank you. This sounded like something.
And look up the Kate Garraway story as well.
Britney's case, it was because they felt she was underage and was managing her money, and that was why her father took over the responsibility.
Okay. Thank you.
The LPAs.
Oh, Leonore, I think there's your line's a bit crackly. No, it's not. Do you want to type it in the chat?
What is the default if no LPAs? The default is then your, for example, your children or your wife would have to go to the Court of Public Guardian to go and seek permission to have access to your assets or access to make the health decisions on your behalf, which can take, let's face it, a lot of the time you would need access immediately, or you'd want to make health decisions immediately. And it's a long process going to the Court of Public Guardian. And it's also an expensive process. Are there any more questions that have come out?
Obviously, if children are under 8, obviously once a child becomes 18, they're an adult, they have to have all these things in place for themselves. But children under 18, it's obviously if something happens and it's the parent. You don't have to have anything in place for them.
It's parental responsibility, which is their mother, their father, or if they're not, their guardians which have been appointed if the parents have been deceased. But yes, it is those with parental responsibility that make these decisions for their children.
Okay. And hence why it's important to have the guardian in place in your will then.
Yeah, all of that, it's just the safety net. Again, we hope that it will never be needed, but if it was needed, it would be, as a result of some awful situation, and you wouldn't need another awful situation. You wouldn't need grandparents squabbling over who had the children, or, contrary sister-in-laws like I've got. You don't want that.
Thank you.
So in the very first instance then, Rebecca, like me, for example, absolutely nothing, probably not any knowledge about where to go. What's the first thing I should do? Is it to go to Google? Do I start searching? What do I do? To
find a local family lawyer close to you. If there's anybody you've worked with, if there's anybody that comes highly recommended from your friends. I mean, okay, in this day and age, it's all a lot of Zoom, but if there are things to be signed, why not support a local business? Go find a local lawyer who you get on with, who understands your situation, and will sort this out for you. If there isn't anybody, then I work with a few lawyers that I can signpost you to, but I would always start local to start with.
Cool, thank you.
Rebecca, you mentioned we can change the will at any time. So say we name somebody, but then we want to remove them. Can they cause an issue while you're changing in your lifetime?
But I guess once you've changed the will, either via codicil, which is a small amendment, or change the whole will, once you've done a new will, once you've created a new will, your old will becomes invalid.
Okay, thank you.
Okay. So yeah, once it's signed, then no, it's...
Rebecca, I've got a question. So I think you said the LPA is valid when you're still alive. It's just someone can make decisions on your behalf, and then the will comes into effect if anything happens to you and you pass away. Right. I'm a single parent, so potentially if I make a will now and have LPA, I will have, say, my sister is my LPA. If I then get married, I know my will is then null and void. I have to draft a new one. But if my sister is my LPA, would that still stand, or does that automatically transfer to the new spouse?
Do you know what? I don't know the answer to that question, to be honest. I would think because it's a named LPA that your sister would still stand, because you may well have different attorneys. I mean, you could, you may, people often have a few attorneys, one for their personal, one for their business, or they put all of their children on there to, just to be equal.
But definitely with the will, it has to be redone. If I ever get married, then I'd have to redo my will. But then it will be obviously to reassess my LPA as well.
Yeah, I would. It's worth it.
Yeah. Okay. Thank you.
Any other questions or thoughts? And hopefully, I've really sort of emphasised the importance of it, and it's not going to make you scared. You're actually going to go away and just get it sorted out. Put it in the drawer and then just forget about it, and it's done. And you've got financial peace of mind that it is there if in the event you ever should need it.
Actually, may I ask a question, Rebecca? What happens if, so if you're not from the UK, but you're living here, you have a will, does that cover all your assets globally or just in the UK, or what would you suggest if I'm sure there are other people on this call who are from different places? I mean, what do people generally do?
A lot of people have wills. If you have got assets here, then a will for your UK assets, and then a will for your overseas assets, because your overseas assets may be covered by the inheritance tax laws in that country, the inheritance laws in that country, rather than the UK inheritance laws.
Okay.
And a lawyer will be able to direct you. Some lawyers work on multi domicile.
Right. Okay. And if you don't have another will, if you don't have a will in that other country, does then that fall into the UK inheritance tax Does that?
You know, that's a question. Ask the lawyers that, because
Okay.
it will
Alright.
a lot of it may depend from country to country as
Yeah.
well. I
Okay.
think it's honestly, it's worth just getting the legal advice to make sure that it's watertight.
Yeah, it's very complicated. Okay.
Exactly.
Yeah. Okay. Thank you.
Rebecca, thank you. I think that was really important, really interesting, great advice, great session. So you didn't give advice, did you?
Retract.
Retract. Yeah. Food for thought for everybody, I'm sure. And thank you so much. Thank you for coming and chatting today. If anybody wants to reach out to Rebecca, I've put her email address in the chat, and please do, because I'm sure she can give some great individual advice to us all. Rebecca, thank you again. Thank you, everybody. I'll hang on at the end of the call if anybody just wants to hang around and have a little chat. Next week, we have just a speed networking session, so no guests. I might be running early from that, Katie, by the way. Sorry, because I have my COVID jab, just to let you know. My second one, because I'm that age. But listen, look forward to seeing everybody next week. Also, for those that didn't join at the very beginning, we have our first in-person event for well over a year. It's on the website. Really want to meet some of you on the 24th of June at the Wine Library. Look it up on the events on the website. But other than that, hopefully see you all again next week. And Rebecca, thanks very much.
Thank you,
Brilliant.
Rebecca.
Thank you.
Thank you, Rebecca.
Thank you. Thank you for all your questions.
Thank you.